My name is Kristen Antolini, and I practice abuse and neglect in Monongalia and Preston counties. And it's a real honor to be here with you today. And I'd like to thank the Court Improvement Program Board for inviting me to speak today. This morning, my topic is a little bit dull. We're going to spend about 25 minutes talking about improvement periods. And as I know that you know, the West Virginia Code in section 494610 outlines 3 types of improvement periods: the pre-adjudicatory, the post-adjudicatory, and the post-dispositional improvement period. And for each type of improvement period, it allows the parent an opportunity to demonstrate to the court that they are substantially able to correct the conditions that led to the filing of the petition. And I know that our topic today is really geared toward guardian ad litem, but a lot of this information also goes with representing adult respondents. And I'm sure just like you probably represent both children and adults. And I think sometimes if we're really working together well as a team, and I'm very blessed in my counties that I feel like counsel really works together, that a lot of times the lines of what the guardian is doing and what the adult respondents counsel are doing can be blurred because we all are working together so well. But before any type of improvement period can be granted, whether it's a pre, whether it's a post-adjudicatory, whether it's a post-dispositional, the parent has to acknowledge the problem. And I think that this is a really important issue for us to talk about today, because I think sometimes attorneys have the mindset that we're just going to file that motion because it's part of our normal practice in abuse and neglect, and we really haven't taken the time, maybe because of our immense caseloads, to really talk with a parent, whether they're the guardian or their counsel, about do they acknowledge a problem. And really under our code section, if they haven't acknowledged a problem, then we shouldn't be granting them an improvement period. So the question is, does the respondent parent acknowledge that abuse and/or neglect has occurred? And if so, has the respondent parent identified the abuser? Our Supreme Court has consistently held that no acknowledgement of a problem equates that there is no reasonable likelihood that the conditions of abuse or neglect can be remedied, and therefore a lack of acknowledgement can potentially lead to a termination of parental rights. In West Virginia v. HHR v. Doris S., a 1996 opinion, the Supreme Court of West Virginia held that where the parent or guardian fails to respond to probative evidence offered against him or her during an abuse and neglect proceeding, a lower court may properly consider that individual's silence as affirmative evidence of that individual's culpability. So our respondent parents cannot simply just remain silent. They have to acknowledge a problem if they want to be successful during this process. And I really feel like helping a parent acknowledge a problem is the make or break step of our abuse and neglect proceedings in so many instances. And sometimes when I'm guardian, I'm the one helping the parent acknowledge that problem, and sometimes when I'm their counsel, I may be the one helping them to acknowledge that problem. I think also we really have to encourage our adult respondents that this is a remedial process, it's not a punitive process. I'm sure just like you, I get lots of questions that they think that this is a criminal proceeding, when in fact it's a civil proceeding. And I think it's hard for them to wrap their mind around that this is remedial, it's not punitive, and we need to be constantly reminding them of that. I'm just going to take a few minutes to kind of talk about some practical suggestions for helping parents acknowledge a problem, because I think just simply going over the petition with them sometimes is just not enough. I think first we have to acknowledge that our respondent parents are broken people. They may struggle with poverty, with substance abuse, with minimal education, with minimal adult life skills, domestic violence in their home, lack of transportation, criminal history, and they may themselves be a victim of childhood trauma that no one has acknowledged, that no one has ever treated, and no one has ever even talked about. I have to remind myself that when I meet these parents, whether I'm their counsel or whether I'm guardian ad litem, I think most of the parents see me as a privileged individual. They see me as somebody who's a lawyer, who's in the courtroom, and it's really imperative that I take time to make sure that they know that I care about their problems and that I am there to listen to them and that I can be a voice of compassion and care to them. But I have to be willing to go out of my way to show that. I can't just simply be nice. And that makes me think of a client that I currently have. Her name is Rose, and I had represented Rose many years ago as a young attorney in legal aid. And all I remembered about this woman was that she had been the subject of significant domestic violence. And when I first talked to her when the petition was filed a few weeks ago, she was very hostile to me. She admitted that she had had a substance abuse problem, but that her husband didn't know that she had used drugs, and he wasn't using drugs. And even though they lived in a 2-bedroom apartment with several children, she felt that if she simply moved out, the husband could have the children and everything would be well. And when I told her that that's not how this was going to happen, her immediate response was, well, I just need a new lawyer. And the easiest thing to do would have been obviously to just file a motion to withdraw and let somebody else handle that. But instead, Rose had a newborn baby that was born drug affected, and it was at the local NICU. And so I contacted the department and I said, hey, she hasn't seen this child since the petition was filed about 10, 12 days ago. Would it be possible for us to make arrangements so that I can supervise a visit for her at the NICU? And the department was extremely gracious, and they called the hospital, they made the arrangements, because I'm her counsel, not the guardian ad litem. I called her and I said, if you could be at the hospital in about 2 hours, I'll be there and I'll supervise the visit so that you can see the baby. And so she met me right on time in the lobby of the hospital, and we went up to the NICU. And in that couple of hours where I supervised the visit, her and I really bonded. I took pictures of the baby, we talked about the baby, we talked with the nursing staff, and everything about Rose and the entire case has changed since I spent that 2 hours with her at Ruby Memorial. She started random drug screening, she's in outpatient treatment, she's already had a psychological evaluation, and we haven't even had the adjudicatory hearing yet. So I think showing compassion and care in a really tangible way helps our adult respondents acknowledge a problem. I think some other ways that we can kind of assist our parents is make sure, if we're representing them, that they have clothing to wear to court. A lot of these people do not have one decent outfit that they can wear to the courthouse. And of course, the clothes that you wear affect how you feel, and it affects your confidence, and it affects how you interact with people. And so obtaining clothing for them for that first hearing is really critical. Sometimes I'll get pictures of the children. If I'm guardian ad litem, I can provide it directly to the parent, but if I'm their counsel, I can get them from the foster care agency, from the department, from the guardian ad litem, and I print those out and I can give them to the parent. Another way is getting them household goods that they may need, getting them bed sheets, getting them towels. You would be surprised at how many of your friends, if you just put it out or in social media, would love to tidy up for you and get rid of their items that don't spark any more joy and allow you to pick those up and deliver them to a client. I've done that numerous times with my Facebook, and your friends are happy because their stuff's gone somewhere good, and these parents have been giving a kickstart in getting their life together, and they know that you care. Sometimes our parents are very impoverished early on in the case, and whether I'm the guardian ad litem or their parent, I don't want to report back from the provider that says, you know, mom and dad didn't bring a snack or an activity. Well, if you can barely feed yourself and your child's in the care of the state, maybe you don't have the ability to bring a snack, a drink, an activity to do. So just taking that little extra effort to provide them with a snack, a drink, it only costs a couple dollars, and it can get that parent started on the right foot. So really, in the end, what can be the result of showing a simple act of kindness? To me, it can be that that parent now trusts you because you've shown them compassion and care, and because of that compassion and care, they're going to be more likely to trust your legal advice if there truly is a problem of abuse and neglect here, and they're going to be more likely to acknowledge that problem and be successful. We have to really show parents that they need to stay out of the weeds in the details that are in a petition. So, these petitions can be 7, 8, 9, 10 pages in some counties, and people can really get hung up on each and every allegation that's contained in a petition, and they get really overwhelmed by that. And I try to help people say, let's stay out of the weeds. The overall problem of substance abuse, the overall problem that there was a physical injury in the home that creates a situation where a child is not safe. The overall problem that this house is absolutely filthy still exists. It doesn't matter if every single sentence in this petition is exactly accurate or not. They're not required under the law to admit to every single allegation in a petition. All they're required to do is acknowledge that an overall problem exists, and I found that really helps me in working with parents. Third, I found that helping parents set up services early on in a case if they can't acknowledge a problem is really helpful. So if you have a good relationship with counselors, get that person into a counseling appointment right away. Call that counselor and say, hey, I have this parent who's having trouble acknowledging that there's a problem here. Can you help me help this parent understand? And they're more than willing to do that. If you have a local rape and domestic violence facility, a lot of times those workers will be glad to meet with your client to help them. One of the biggest assets that I've used recently is calling Help for West Virginia. How many people have called the Help for West Virginia line? Not as many as I thought. I think that Help for West Virginia is one of the greatest things that the department has really done in years, because the people who answer the Help for West Virginia line, most of them are in recovery or have had some kind of substance or mental abuse recovery process and treatment in their lifetimes. And a lot of times, whether I'm guardian ad litem or I'm their parent, I'll say, hey, it looks like to me that you're actively using, or hey, I think that you could really benefit from going to a 28-day program. Let's sit down and call them. And I've done this a number of times recently with both when I'm guardian ad litem and when I'm representing a parent. After the hearing, I've sat down with them and I've called Help for West Virginia. And I simply dial 844 Help for West Virginia, and I tell the person on the line who I am and who I have with me, and I put it on speakerphone, and I tell them that this is the situation that we're in. Can you tell them some of the services that are available for them? And that person on that Help for West Virginia line is able to typically connect with the person better than I can, because they've had this experience. And I believe in doing this so strongly that I actually even did it with one of my own relatives. We called Help for West Virginia together, because what we have to remember is that if you're in crisis as an adult respondent, it's too difficult to really get those services started on your own. We can't simply say, hey, you need to call this number and you need to set up these services, because they can't. They need you to make that first step to dial that number, explain what kind of services are needed, and then go from there. And even if a parent doesn't maybe go to treatment that day, I still believe that they're more likely to go if they've at least had that experience with you of calling into the hotline and seeing what it's all about. And if you haven't used Help for West Virginia before, they also have the service of, if your client doesn't have a medical card, they can make that application for you and they can get it back within 24 hours. It's amazing. They can also set up transportation paid for by Medicaid, and so that person can be picked up at their apartment, at their home, and taken to and from treatment. So I highly recommend that you give them a call. If you're not familiar with the services, you can also just call them and say, hey, I'm an attorney in the state, can you tell me a little bit about what you do, so that you can get more familiar with it. So in sum, if your client can acknowledge a problem, then that parent at that point is going to be in a position to ask for an improvement period. And additionally, of course, the steps that you've taken to help them get to that point are going to get us to a place where reunification is more likely. So we're going to talk a little bit about the 3 different types of improvement period, and I know that most of you know this, but I was given the task of going through these. So the pre-adjudication pre-adjudicatory improvement period, pursuant to West Virginia Code Section 494610(1), the court may grant a 3-month improvement period with no extension available prior to finding that a child is abused and/or neglected. And the code section clearly sets out what the responsibilities of each party are in the case. It tells you what the court has to do, what the department has to do, and what the respondent parent has to do. So here it requires the respondent parent file a motion and demonstrate by clear and convincing evidence that he or she is likely to participate in the improvement period. It tells the court that the court has to review the pre-adjudicatory improvement period at the 60-day mark and the 90-day mark, and it tells the department that they must file an individualized case plan and prepare a progress report in 60 days. For the post-adjudicatory improvement period, that's a 6-month improvement period with an extension available. Yes?
Before you move on, in a pre-adjudicatory improvement period, there's no admission of abuse, neglect, or abandonment. How do you reconcile that with having them admit that there's a problem?
So I guess my response to that would be, you're just having a parent go through the motions, and I don't feel like I'm doing my job as an abuse and neglect attorney if I'm simply saying that we're going to just have this pre-adjudicatory improvement period and you're going to jump through these hoops and then you're going to get your children back. I can't sleep at night doing that. It's not that you have to necessarily admit to the court, I guess, yes, so-and-so, beat my child, but I think you do have to admit that there are circumstances that need to be improved upon. I mean, I think really all you're buying with a pre-adjudicatory is not having an abuse and neglect adjudication on your civil record, if there's a check or into that. Otherwise, I really think that the parent, and I'm sure maybe other people have different opinions about this, I feel like the parent still has to admit that there's some kind of problem here. And I've even had parents just admit that the child perceives that there's a problem and the child doesn't feel that it's safe enough, and so we need to do this. And most parents are willing to do that. And I understand what you're saying, but I think all you're really buying with that pre is not having that stipulated adjudication or the court finding the adjudication. Otherwise, I think you're really saying that there is still a problem here that we need to be fixed. Otherwise, you'd be fighting adjudication. So back to the post-adjudicatory improvement period. It's 6 months with a 3-month extension available. And again, the respondent parent has to file a motion and has to demonstrate by clear and convincing evidence that he or she is fully likely to participate in an improvement period. I hear counsel from the department saying this all the time. Well, they already had a pre and they didn't do well, and so we're not going to give them a post. We don't have to under the code. I hear that often. And I don't really think that that's accurate under the code section. I think what you really have to do is you have to show if they've already had a pre and maybe they needed more time or wasn't successful, what you really have to show is that there's been a substantial change in circumstances that's going to show that they are going to participate now. And I think an example of that is if maybe somebody had a pre for a substance abuse case that probably shouldn't have because you need more than 3 months, and they went to maybe detox and outpatient and then they relapsed and it wasn't enough. I think to show that you have a substantial change in circumstances to get a post, you've got to have a plan for their treatment, and they better have a 28-day treatment bed or a sober living bed or some kind of bed. I think that's an example of what a substantial change in circumstances would be that would allow them to have a post after they haven't successfully completed a pre. Again, the code requires the court to review, but only here is at the 30-day mark and the 90-day mark, and it requires the department to submit an individualized case plan and a progress report. The post-dispositional is also 6 months with a 3-month extension available. It requires that parent to file a written motion. It also, again, requires that if there was a previously granted improvement period, that there is going to be a substantial change that's going to show that they're going to either continue to be in compliance or that they're now going to show compliance. And the code requires that the court review the improvement period at the 60-day and the 90-day mark, and requires the department to submit an individualized case plan and a family progress plan. But whether you're getting an extension for a post-dispositional, whether you're getting the post-dispositional at the onset, whether you're getting an extension for the post-adjudicatory, especially if your children are in foster care and not in kinship placement care, you're going to have to show that an extension will not substantially impair the department's ability to permanently place a child, and that the extension is in the best interest of the child. And I think as guardian, you really have to have a sense of, is this case dragging out too long, or does this child need permanency now? And these parents who have kinship placements are sometimes a little bit more fortunate than our parents that don't have their children in kinship placements, because I think it is a little bit easier to get extensional time when the parents are with, when the children are with grandparents rather than in traditional foster care. Just real briefly, the written motion for an improvement period. These are some of the questions that I asked parents, and this actually came out of directly my motion that I submitted in every case for an improvement period. So I state whether the parent has been previously granted an improvement period, whether they're likely reasonably to participate. Will the parent participate in the MDT and follow the recommendations? Will the respondent parent sign the consent and release forms? And I try to have them do that at the MDT or at my office or at the court hearing, because sometimes it's a little bit difficult to track down these parents to have them sign releases. Will the respondent parent be honest? Will they keep their appointments? And have they participated in all court proceedings to date? Will they participate in the development of a family case plan? And if the improvement period is granted, will it cause an unnecessary delay? And does the parent understand that they are responsible for the initiation and completion of all terms and conditions of the improvement period? Something that I do as part of my improvement period motion and that I like for the court to do is I kind of like to consider that improvement period motion as a contract with the parent. So in my motion for an improvement period, I always lay out exactly what their services are going to be. So if they're going to go to a 28-day treatment bed, I put that in there. If they're going to go to sober living, I put that in there. If they're going to do parenting and adult life skills, I put that in there. And then I like for the court to order whatever services that are in that motion, whatever services the department is requesting, to also put that in the order. And Natalie spoke about that a little bit, but then there's no confusion with the parent about exactly what they're supposed to do. If it's outlined in the motion, if it's outlined on the record, if it's outlined in a court order. I think one thing that's a little bit hard sometimes for parents to wrap their head around is that they're responsible for the initiation and the completion of all services, and our parents need help with that. The other thing that's good to kind of keep your thumb on, whether you're a respondent parent or guardian as litem, is the payment of services. The department is supposed to bear all expenses, reasonable expenses, that the person cannot pay for. I think a good example of that, for example, would be if a respondent parent is going to go to a sober living. That's not automatically going to be paid for by the department. However, if you make a motion and get an order, your judge will likely give you an order that says the department shall pay for that sober living fee, and the department, in my experience, has been happy to pay for that. They just need an order. So be proactive, whether you're guardian litem or their counsel, to get orders to pay for things that may not be automatically paid for. How long can a respondent parent have consecutive improvement periods? As you know, the code section says that no combination of improvement periods or extension should result in a child remaining in foster care for more than 15 months of the most recent 22, unless the court finds compelling circumstances that it's in the child's best interest to extend this time limit. And then just real briefly, when to object to an improvement period. And these kind of come right out of the code sections. When a child has been abandoned, tortured, chronically abused, sexually abused, when a parent's not demonstrated that they're going to participate, when an improvement period would jeopardize the best interests of a child, when their parental and custodial responsibilities to another child have already been terminated and they don't acknowledge a problem and they've made no steps to remedy any of the conditions of abuse and neglect in either case or multiple cases, If a parent is on a sex offender registry and reunification with this child is not going to be in the child's best interest, or there is some code section that talks about murder, sexual abuse, I think those things are pretty obvious. When do we move the court to terminate an improvement period? Any party can move to terminate. So another parent can move to terminate another parent's improvement period, the guardian, the department. I think we usually think of it, though, in the mindset of the department or the guardian will move to terminate an improvement period. But I think the basis for a termination is the parent is just not participating. Sometimes it's good to file that motion as guardian to terminate, because when they realize we're having a hearing on this motion, sometimes they decide that they're then going to get their ducks in a row to get everything done to start really participating. And just finally, what are the guardian ad litem's responsibility during an improvement period? That's the section from our appendix that shows that, but I guess in some, my thought on that is our THHR workers are very understaffed, they're overworked, and I think as guardian, it's really our responsibility to step in and set up some of those services, put in some of those referrals, and stay in touch with those providers to make sure that everything is on track. There's a lot that you can do as guardian ad litem to really assist the worker. You can also set up a psychological evaluation, do an order for payment. And so I think your duty as guardian ad litem, more than anything, is to really assist and make sure that all of these services, both for the child and the parent, are being put in place and help the department in any way that you can. I thank you this morning for your time, and I look forward to seeing you this afternoon.